Good afternoon, ladies and gentlemen. Good afternoon. May we have your attention? I would like to, yes, please. I would like you just to lower your camera so that those at the back can also, yes. Is it low enough? Colleagues? All right. Thank you and good afternoon once again. My name is Khalalelo Masibi and I am the spokesperson for the Public Protector. I will be chairing today's session. I would like to welcome you all and thank you to some of you who made it to the media lockup this morning. I would like to welcome members of the media. I would like to welcome staff members and members of the public who have also joined the briefing. I will start by asking you to observe the following housekeeping rules. Please put all your cell phones on silent. And we will have the opportunity for one-on-ones after the Public Protector has addressed you. And as usual, before you ask a question, we are going to ask you to identify yourselves and tell us the media house that you represent. The Public Protector will only entertain questions from journalists at the end of her briefing. If anybody else who does not work or represent any media house has a question, they will be given an opportunity at another time and at a different platform. The hashtag for this briefing is at Nkandla Report, and another hashtag is at PP Presser. I'm going to introduce the panel and hand over to the Public Protector. On my far left is the CEO of the Public Protector, that is Mr. Themba Mthethwa. Next to Mr. Mthethwa is the Deputy Public Protector Advocate Kevin Malunga. And next to the Deputy Public Protector is the Public Protector of South Africa Advocate Tuli Madonsela. I will hand over to the Public Protector to address you.
Program Director and Spokesperson of the Public Protector. My apology that we're starting a little bit out of time. Greetings on behalf of the Public Protector team. Primarily, I would like to greet the Deputy Public Protector, Advocate Kevin Malunga, the Chief Executive Officer of the Public Protector South Africa, Mr. Themba Mthethwa, members of the investigation team that are assisting me in this investigation, you members of the media who have taken the time to join us this morning, any members of the public that are here and who have taken an interest in this briefing, people of South Africa that are joining us this morning, or rather this afternoon, through several TV and radio live broadcasts. We are humbled by your interest in today's media briefing and wish to convey our gratitude to you for ongoing interest in the work of this constitutional institution, the Public Protector South Africa. To the media and the people of South Africa, my team and I are sincerely grateful to you for your ongoing facilitation of dialogue on ours and other investigations on maladministration, ethical conduct, and other forms of improper conduct in state affairs. I've previously said that the facilitation of public dialogue is the key to my office's ability to support and strengthen constitutional democracy as envisaged in sections 181 and 182 of the Constitution. It is often said that the judiciary is disadvantaged in comparison to the other branches of government because the judiciary neither controls the purse nor the sword in the public sector. And this is often used as a reason why the judiciary needs to be protected and its independence guaranteed. The public protector forms part of the ombudsman family. This group of institutions is a fairly recent innovation in the area of public accountability. The institution was introduced in Sweden to address gaps in traditional checks and balances within the public sector a little over 200 years ago. We have learned that the King of Sweden got the idea from his travels in the Middle East. We have since discovered that there are parallels between the public protector or the ombudsman office as an institution and some of our own non-political institutions that served to curb excesses in the exercise of public power in traditional communities. One of these institutions is the Makatsi, which we have adopted as one of our institutional symbols. The Makatsi, an aunt, is a non-political figure who serves as a buffer between the ruler and the people. It is said that a Makatsi whispers to the ruler about the complaints of the people and indicates where she thinks there's wrongdoing and advises on how to correct the situation. It is also said that a ruler who ignores a Makatsi does so at his own peril. I'm saying at his own peril because traditionally the ruler would be a man, except if we're talking about the Rain Queen, where there is no Makatsi. In modern South Africa, this is one of the innovations of constitutional democracy. The public protector is part of innovative constitutional institutions that are meant to help the people exert accountability in the exercise of state power and control over public resources through administrative scrutiny. Administrative scrutiny is a novelty on its own. Implementation of decisions is not through hard power as exercised by the courts and the other branches of government. Ours is to strengthen constitutional democracy primarily through facilitating dialogue between the people and those they have entrusted with public power. Our strength lies in what we refer to as moral suasion, or others would call it moral persuasion. The media is essential in this regard. Media involvement is also essential as part of an open and transparent state. Excuse me. As a nation, we chose open democracy and public accountability and openness form part of the founding values entrenched in Section 1 of our Constitution. Excuse me, I have sinus problem. My office has a further responsibility under Section 182(4) to be accessible to all persons and communities. Again, without the media, it would be impossible to comply with this injunction. We use media briefings for the dual purpose of keeping the people abreast of developments in our work while ensuring accessibility to our services. Not all our cases come to media briefings like this one. Most of them are resolved through the Makatsi way of whispering to appropriate public authorities about wrongdoing. Last year, for example, we received over 33,000 cases, and this year our workload exceeds 40,000. Most of those cases involved people we refer to as Gogo Dlamini, people who would not on their own be able to tackle injustices in the exercise of state power. It is important to know that, like the Makatsi, we do not make the rules. The rules are made by those who are governed and those who govern. We are just the keepers of the rules. I now turn my focus to the subject of today's briefing. Today we are gathered to hear the outcome of an investigation I have carried in my capacity as public protector into security upgrades at the President's private residence. As we listen to my findings, I would like us to keep in mind the following quote from former Judge Brandeis. It says the following: "Our government is the potent, the omnipresent teacher. For good or for ill, it teaches people by example. If the government becomes a lawbreaker, it breeds contempt for law. It invites every man or person to become a law unto himself." Secure in comfort is my report as the public protector of the Republic of South Africa on an investigation conducted into allegations of impropriety and unethical conduct relating to the installation and implementation of security and related measures at the private residence of the President of the Republic of South Africa, His Excellency J.G. Zuma, at Nkandla in the KwaZulu-Natal province. The report starts with a quotation from one of the officials that were involved in the project, where he was concerned that the project started from humble beginnings, and at that time he said that they needed to plan for a township. At the time this director of architectural services made the remark, the cost estimation for the project was around 145 million. By the time I concluded this investigation, 215 million had been spent, while the total cost to conclude the project was conservatively estimated at 246 million. He made this comment because when the project was authorized through a memo at the Department of Public Works, the total project plan estimated that the work involved was going to cost government 27 million. The investigation was conducted in terms of Section 182 of the Constitution. Section 182 of the Constitution gives the Public Protector the power to investigate alleged or suspected improper or prejudicial conduct in state affairs, to report on that conduct, and to take appropriate remedial action. The investigation and the report are also in terms of Section 6 and 7 of the Public Protector Act number 23 of 1994, which regulate the manner in which the power conferred by Section 182 of the Constitution may be exercised. Part of the investigation was also conducted in terms of the Executive Members Ethics Act 82 of 1998, hereinafter referred to as the ENI, which confers on the Public Protector the power to investigate alleged violation of the Executive Ethics Code at the request of members of national and provincial legislatures, the President and Premiers. The investigation was carried out in response to 7 complaints launched between 13 December 2011 and November 2012. The first complaint from a member of the public was lodged in terms of the Public Protector Act on 13 December 2011. It's going to be important that we understand the two acts, the Executive Members Ethics Act and the Public Protector Act, because there are implications for investigations under either of the two. Other complaints followed thereafter, also lodged under the Public Protector Act. Further complaints were received from ordinary members of the public, and a year after the first complaint, a member of Parliament lodged a complaint under the EMI, or the Executive Members Ethics Act. The first complainant requested an investigation into the veracity of allegations published by the Mail and Guardian newspaper on 11 November 2011 under the heading, I quote, "Banka Time, Zuma's lavish Nkandla upgrade," close quotes. According to this media report, the President's private residence was being improved and upgraded at enormous expense to the state, estimated at about 65 million at the time. The impugned improvements allegedly included a network of air-conditioned living quarters, a clinic, gymnasium, numerous houses for security guards, underground parking, a helicopter pad, a playground, and a visitors center. The earliest concerns regarding opulent or excessive expenditure at the private residence of President Zuma were expressed on 4 December 2009 by the Mail and Guardian in an article titled Zuma's 65 million Nkandla spillage. Apart from the release of a statement by the presidency on 3 December 2009 denying that government was footing the bill, nothing seems to have been done by government to verify the 2009 allegations or attempt to arrest the costs which the article predicted would continue to rise. Just to explain that, In 2009, the Mail and Guardian published an article complaining that there was excessive expenditure, and at that time it was costing 65 million. That was in November 2009. In December 2011, the Mail and Guardian published another article on the same issues, this time estimating the cost at 200 million. When the first article came out in 2009, the Mail and Guardian had warned that the cost was rising. It will be indicated in the report that there's no evidence of anything being done to find out what was happening and to confirm whether or not the cost was rising. When the new article came out in 2009, the first complainant approached my office and requested an investigation. This was in 2011, December. A complainant requested us to investigate. And according to information we could get during the investigation, nothing was done previously, and nothing was done for that year after we started the investigation until 2 years later, when the Minister of Public Works then appointed a task team. In the report, you will notice that I have indicated that as the project proceeded, more items were added to the project, despite the complaint that had been raised as early as 2009. And that's why the cost then rose to the 215 million that we have now confirmed was spent. We have also confirmed that the work is incomplete and that the total cost is going to be at least 246 million. Some of the questions that were raised in the written submissions of the complainants were the following: where is the money coming from and how has it been approved? Whether any undue political influence was placed on the Department of Public Works to allocate these funds? Who issued the instruction for the allocation of these funds? Whether these funds have been properly budgeted for? Whether any funds have been transferred from other much-needed projects for this revamp to take place? Whether the allocation of funds for what is essentially a private home, which will not remain within the state's ownership, represents irregular expenditure? How can this amount be spent on a private residence of any government employee? The additional complaints raise issues regarding the possible abuse of executive privileges, impropriety, and that benefits may have been extended to relatives. There was also an allegation that the President may have misled Parliament. I will indicate later what the exact complaint was. Included in the complaints were the following significant statements. I quote, I do not understand how this money can be spent on a private residence of any government employee, especially when that employee has 2 residences at his disposal in Cape Town and Pretoria. Close quotes. Another statement was the following, open quotes, whether this construction is being performed for President Zuma as President of South Africa, as a political favor as ANC President. I would suggest it is misuse of state funds for the benefit of a private individual, possibly to carry political favor for the Minister of Public Works or a DG. When the President is no longer the incumbent, he is not entitled to state housing, but he will enjoy the benefits of the modifications to his private estate in perpetuity. Close quotes. The last statement we have extracted from those complaints reads as follows, I quote, while the majority of people in this country will struggle and fight for survival, it is deeply disturbing to discover that the President and some of his close senior supporters feel that it is all right to abuse their positions to benefit themselves and each other at the expense of the nation and all her citizens. These individuals, in their capacities as servants of the people, should be held to task if they are in any way guilty of wrongdoing, abuse of power, or corruption. If the allegations in the press on what is happening with the President's private homestead in Nkandla are true, then the President and those involved in facilitating these massive renovations are possibly guilty of a number of transgressions and should be held accountable. At least these allegations should be grounds for you and your team to conduct some sort of investigation. We've underlined this because there's a dispute about what exactly was the complaint. Was the complaint about procurement, or did the complaint include allegations of impropriety by members of the executive? In essence, the complaints alleged the following. 1, there was no legal authority for the expenditure that was allegedly incurred by the state in respect of upgrades made at the President's private residence in the name of security. Even if there was authority, the upgrades were excessive or opulent and transcended such authority. 2, the procurement process was improper, in violation of prescribed supply chain management policy framework, and resulted in unduly excessive amounts of public money being spent unnecessarily. 3, the conduct of the President in relation to the implementation of the impugned upgrades at his private residence may have been unethical and in violation of the Executive Ethics Code. Based on an analysis of the complaints, the following issues were identified and investigated. All in all, the issues identified and investigated were 12. 1, was there any legal authority for the installation and implementation of security measures and the construction of buildings and other items by the state at the President's private residence? And was such authority violated or exceeded? 2, was the conduct of relevant authorities in respect of the procurement of goods and services relating to the upgrades improper and in violation of the relevant supply chain management prescripts? 3, did the measures taken by the Department of Public Works at the President's private residence go beyond what was required for his security? 4, was the expenditure incurred by the state in this regard excessive or amount to opulence at a grand scale as alleged? 5. Did the President's family and/or relatives improperly benefit from the measures taken? Buildings and other items constructed and installed at the President's private residence. 6. Was there any maladministration by the public office bearers, officials, and other parties involved in this project? 7. Was there any political interference in the implementation of this project? 8. Were funds transferred from other much-needed DPW projects to fund this project? 9. Is the President liable for some of the cost incurred? 10. Were there ethical violations on the part of the President in respect of this project? 11. Are there other administrative issues that arose from the complaints and the investigation process? 12. Are there systemic deficiencies regarding the administration of benefits of presidents, deputy presidents, former presidents, and former deputy presidents? The investigation focused on security installations at the President's private residence situated in a village known as Nkandla in KwaZulu-Natal, where he was born and had spent most of his life, save for the years when he was in prison and later exiled. President Zuma is the 4th president in democratic South Africa. The security installations commenced shortly after he was elected and sworn in May 2009 as the President of the Republic. The period covered by the investigation runs from the date of the first security evaluation done on the requirements to upgrade the security at the President's private residence, which was done on 19 May 2009, and the investigation period ends at the end of January 2014. The substantive scope has focused on compliance with applicable laws and policies in relation to security privileges accorded to presidents, deputy presidents, former presidents, and former deputy presidents. We've also looked at compliance with supply chain prescripts. We've also looked at compliance with Department of Defense prescripts relating to transporting presidents and providing medical care. Lastly, the scope of the investigation has also dealt with the conduct of the President and others allegedly involved in the implementation of the upgrades. The laws and policies that informed the investigation were principally those relating to the authority to implement the upgrades. The main legal instrument we relied on was the Cabinet Policy of 2003. For reasons that will be explained later, we also looked at the National Key Points Act of 1980. We've also been guided by laws and policies relating to public procurement. These include Section 217 of the Constitution, the Preferential Procurement Policy Framework Act of 2000, the Public Finance Management Act of 1999, and Treasury regulations. In relation to the role of the Department of Defense, the provisions of the South African Defense Review of 1998 and the Defense Act of 2002 were considered. These were considered together with institutional policies regulating the provision of medical support and securing the President and others while in transit. I was particularly mindful of the fact that the current regulatory framework does not distinguish between permissible measures for securing the private residences of presidents, deputy presidents, former presidents, and deputy presidents. In respect of the Department of Defense, I was further mindful of the fact that the regime relied on for the provision of health care, being paragraph 22 of Chapter 7 of the Defense Review, covers the President, Deputy President, Minister and Deputy Minister of Defense, and foreign dignitaries visiting South Africa. In other words, if I were to reach a conclusion that what was done at Nkandla was permissible for a sitting president, I would be saying that the same measures are permissible for the others. This would inevitably lead to questions of affordability and sustainability, not only in the context of the current fiscal climate, but also in terms of balancing the competing needs of South Africa as a developmental state. I also had to take into account Section 237 of the Constitution, which directs that, I quote, all constitutional obligations must be performed diligently and without delay, close quote. We also had to take into account Batupili, the white paper on transforming public service delivery, published in 1997, which undertakes to transform an inherited, inward-looking state to one that puts people first as the true targeted beneficiaries of public resources and services. The conduct of the President was primarily assessed against the pursuit of ethical standards imposed on members of the Executive by Section 96 of the Constitution and the Executive Ethics Code, issued under the Executive Members' Ethics Act. To unpack the provisions of the Constitution and the Code, I took into account previous investigations of my office, the Public Protector South Africa, on executive privileges. The key investigations that I looked into is the one where I scrutinized the conduct of the Minister of Police in relation to accommodation privileges. I also looked at the findings I made in relation to the use of accommodation and travel privileges by the Minister of Cooperative Governance and Traditional Affairs and by the Minister of Agriculture and Fisheries. With regard to the Minister of Police, this report has also taken into account findings of the Auditor General regarding alleged excesses in relation to the construction of a security wall at his private homestead. I must just indicate up front in that regard that the Auditor General had found that exceeding what the law provided was irregular and that the excess amount had to be paid by whoever was responsible for the irregularity. Consideration was also given to global benchmarks, principally on the role of those entrusted with public power and control over state resources. Key to this scrutiny was the issue of balancing people's rights to resources and self-maintenance for those who are entrusted with public power and resources. The approach to the investigation included correspondence. Inside the report, I indicate who we corresponded with. I would like to single out correspondence conducted between my office and the Presidency, the Ministry of Defense, the Department of Public Works, and the South African Police Services. With regard to this, there was a lot of correspondence between my office and them. The first letter to the President informing him about the allegations was in January 2012, which was shortly after the complaint was filed, the first complaint having been filed in December 2011. We conducted interviews with the following: former Minister of Public Works, Ms. Gwen Mahlangu Nkabinde, the Deputy Minister of Women, Children and Persons with Disabilities, who was the Deputy Minister of Public Works at the time. We interviewed officials from the Department of Public Works, South African Police Services, and the Department of Defense. I've also indicated many other people that we interviewed. In addition to the interviews, we held meetings with the President, which took place on 11 August 2013, the Director General in the Presidency, with whom I met in January 2012 and in December 2013. There were group meetings with the Ministers of Police, Public Works, State Security, and Justice. The Minister of Defense joined one of those meetings. The Chief State Law Advisor, the State Attorney, and several officials from the participating departments were also part of those meetings. Also attending those meetings was the former Surgeon General, Lieutenant General V. Ramlakan, whom we also interviewed. I also had meetings with the Acting Chief of Staff in the Ministry of Police, Ms. Jenny Irish Koboshian. We secured and analyzed voluminous documents, which include correspondence, applicable laws, policies, and other prescripts. We also looked at previous reports of this office, as I've indicated earlier. We've also looked at international benchmarks, particularly in the area of ethics and executive privileges. On 12 August 2013, we conducted an inspection in loco where we visited the site at Nkandla in the company of the Minister of Defense, members of my investigation team, and officials from the Department of Public Works and the Department of Defense. After concluding a provisional report, affected parties were served with Section 7(9) notices, and we received submissions in response thereto. The President was given a copy of the full provisional report and a Section 7(9) notice as well, and we received submissions from him as well and had a meeting with his lawyers. Limitations of the investigation. The investigation took approximately 2 years, which exceeds our target as the Public Protector South Africa. Our strategic plan seeks to conclude investigations within 12 months if they're complex, and a shorter period if they're urgent and simple. The delays can be attributed to the following: internal capacity constraints, access to classified information, access to the report of the internal task team appointed by the Minister of Public Works, objection lodged by the Minister of the Police on 22 March 2013, later supported by the Ministers of Public Works and State Security, with the assistance of the Acting State Attorney and the Chief State Law Advisor to the investigation. General delays in accessing information held by some of the departments, Lastly, we also experienced lengthy delays in regard to responses to the Section 79 notices. When we were not able to extend timelines, we were threatened with litigation, and in some instances we reviewed the decision not to extend the timelines. You will recall that when the ministers of police requested an extension of the timelines to comment from a security perspective on the early draft of the provisional report, they too took this office to court. We also experienced problems with the issues of jurisdiction. There were those who challenged jurisdiction, although improperly so. One of the key challenges was the issue of security, which I will deal with later in the report, where it was argued that this office should not handle this matter in the light of the fact that the ministers had commissioned an internal task team to handle this matter, and the task team had made a decision or had recommended that the Auditor General and the SIU be asked to conduct an investigation. It didn't matter to them that at the time the task team concluded its report and made that recommendation, this investigation had long been initiated. One of the private consultants also challenged the power to investigate persons, the conduct of persons who are not employees of the state. Inside the report, I talk about how I dealt with that. We experience difficulties in accessing information that is classified. I will talk more broadly about that. The security nature of the investigation presented problems. Government wanted us held to the provisions of a document called Minimum Information Security Standards Policy. This is a document of the Cabinet, and as you know, the Public Protector is not part of the executive and accordingly operates in terms of the law and the Constitution. But initially there was that misunderstanding that we are bound by the provisions of MIS and that we could not access documents or use documents that we classified. However, that misunderstanding was clarified and we were able to proceed, but that was months later after we'd been requesting information. From my side, though, there was also the question of how much information was going to be revealed to the public. In deciding how much information was going to be revealed to the public, I took into account the provisions of the Constitution and the Public Protector Act. The default position in both the Public Protector Act and the Constitution is that the public has to be informed. And of course, this is in line with the provisions of Section 1D of the Constitution, which entrenches accountability, responsiveness, and openness among other founding values of our democracy. However, it was also important to ensure that we comply with the protection of state information, because there's a good reason why certain information has to be protected. I choose not to discuss that right now. But basically, in striking that balance, we were guided by two things. Firstly, it was information that was already in the public domain. And secondly, it was information that government had already given to the public in response to a protection of access to information directive from a court of law. About 12,000 pages of documents were already in the public domain, having been released by the Department of Public Works under the signature of the Minister of Public Works. In my approach to the issues of ethical considerations, I was faced with asking the President the same questions I had asked his ministers under the same Act and the same code. In particular, when I had investigated allegations of excesses in the use of privileges against the Minister of Police, some of the questions I had asked were included whether or not he had raised questions about obvious, extravagant, and expensive measures that were being extended to him. You will recall that we issued a report, and the report that was called The Ethics of Staying in Comfort indicated that the Minister of Police had himself asked those questions when he was placed in an expensive hotel. He had asked how much it was going to cost and whether this was allowed under the law. And when he wasn't happy with the answers given to him, he had requested to be given less opulent quarters. The normal approach to our investigations was applied, and the questions we ask are generally what happened, what should have happened, and whether there is a discrepancy between the two, and if such discrepancy exists, does that constitute improper conduct and maladministration? And if we make a determination that there was maladministration, we then decide how to remedy the maladministration. Before I go into findings, I have made general observations that will give context to the findings. I will now just read those general observations under each of the 12 issues that were investigated. You will recall that I have said that the first issue was whether there was legal authority to install the security features at a private residence at state expense, and whether it was true that even if such authority existed, it may have been exceeded. My simple finding is that the security upgrades at private residences are allowed as privileges accorded to members of the executive and other parties whose security is essential to the functioning of the state at owner's request. In the case of the President and Deputy President, the Presidency is also authorized to make the request. The important thing, though, is to understand how are those privileges regulated. For ministers, these privileges are regulated under the Ministerial Handbook. However, as the President, Deputy President, former Presidents, and former Deputy Presidents are excluded from the handbook, there's a separate regime for them. It is called the Cabinet Policy of 2003. And the Cabinet Policy talks about the extension of such security measures to these 4 groups. Regarding the installation of health-related services and transport for the President, the prescripts that guide such include Department of Defense doctrines relating to transporting and providing medical services to the President, Deputy President, former Presidents, and former Deputy Presidents. It was these two regulatory frameworks that should have been considered in regulating what we are talking about, being the upgrades at the President's private residence in KwaZulu-Natal. According to a declaration certificate issued by the Minister of Police, the Nkandla private residence of President Zuma was declared a national key point on 8 April 2010. The presidency has denied that the National Key Point Act regulated the extension of privileges to the president, and so has the Ministry of Police. You will notice in my findings later that I have not been able to agree with the submissions of the presidency and the Minister of Police in this regard. The reason being that when declaring the president's residence as a national key point, the Minister of Police specifically requested the President to pay for security upgrades to secure this national key point. As indicated earlier, security measures at private residences would not be automatic, meaning that if it was under the 2003 cabinet policy, the president would have had to request these upgrades, or the presidents would have done so. If it was under the National Key Points Act, it would be on the basis of whatever had been decided by the Minister of Police. Then we deal with the issue of the upgrades made in relation to the provision of health services and transport. We will indicate what those are. Those would have had to be regulated under the prescripts of the Department of Defense. I must indicate that the prescripts that we were given to my office by the Department of Defense do not deal with any permanent security installations at a dignitary's private residence. They do, however, deal with the provision of military medical services, including the installation of military clinics and other facilities. I now deal with whether the authority was complied with. Firstly, we have indicated that the policy framework under the 2003 cabinet policy requires that there should be two things: a request and a security evaluation. The evidence shows that such security evaluation was done. The first one was done in May 2009, and another was done a year later. However, no evidence has been presented or found indicating that somebody requested these privileges as required by law. We've established that the process started in 2009, and since the place was only declared a national key point more than a year later, the instrument or the enabling framework that needed to be complied with would have been the Cabinet Memorandum of 2003, which we refer to as the Cabinet Policy. We found no evidence indicating that the presidency requested this or the president himself requested this. This is the trigger mechanism that is stipulated in paragraph 812B1 of the Cabinet Policy of 2003. I have, however, been persuaded by submissions by various representatives of organs of state that are involved in the project, who have indicated that the normative practice is not to wait for a request. You know that you have to secure the president. They have indicated that over the years, the approach that has developed involves automatically going to the private home of the president and assessing the security needs. There's also documentary evidence that the upgrades, there was reason to undertake some upgrades. And the upgrades were undertaken using, or rather, the assessment was undertaken using the Cabinet Policy of 2003 and a document called the Minimum Physical Security Standards. It lists what needs to be done, and they did use that document. They then costed the measures at about 27 million at the time. This was May 2009. Another evaluation was done later, again by the security experts as required under the 2003 Cabinet Policy. Again, they used the same document, the Minimum Physical Security Standards, and they listed items that they considered necessary to secure the president. You will note later in the report, though, that there are items that were ordered by the security experts, and there are items that were not ordered by the security experts. Having looked at everything that has been brought to the fore during this investigation, it would appear that the course of events changed significantly in August 2009. What happened in August 2009? After the first security upgrade, after the first security evaluation was done, DPW took the outcomes document, processed it, and internally there was a decision made to go ahead and implement. And by August, they were at a stage where they were implementing, not decided what needed to be done because the assessment had been done. But during the implementation process, they decided to engage consultants that were already on site, working for the president in his private capacity as a citizen. One of those people was Mr. Makanya, the president's private architect. He was brought in August to become the principal agent for DPW in respect of the entire project. What you will see in the report is that during this period, during a short space of time after this engagement of Mr. Makanya, the scale of the work increased exponentially, leading to installations that were not on the lists that I've spoken about. At that stage, we're still talking about the first list that had been created by the security experts. It was in that context that the Director, Architectural Services, expressed concerns about moving from humble beginnings to establishing a township. I will talk in the findings then. What do I make of this? But basically what we can say here is that there was a security to install those upgrades. There was authority to install the upgrades, but the security had to be exercised within certain parameters that were given by the Cabinet. So the Cabinet created the Cabinet Policy of 2003, and in support of that Cabinet Policy, there was a minimum physical security standards. But in addition to that, there was also practice, because this was not the first president of South Africa generally, and certainly not the first president of democratic South Africa. Let us briefly indicate what the requirements of the Cabinet Policy are. It requires that there should be a request by the President or Presidency for security measures. There should be a security evaluation by the South African Police Services and State Security Agency. Then there should be a proposal to the Interdepartmental Security Coordinating Committee. A cost estimate must be prepared by the Department of Public Works. The South African Police Services must then advise the Minister of Police on the proposed security measures, including what those measures are going to cost. The Minister of Police must communicate to the President on the approved security measures for his consent, and DPW must then implement. The evidence you will find in the report shows that these were not complied with, except for the security evaluations. Everything else was not done. There's no evidence that anything of it was done. There was the initial cost estimate done by DPW, but that was not given to the Minister of Police, and it was certainly not communicated to the President in any document that we are able to find. And certainly there was implementation by the Department of Public Works. We were then left with asking a question: if the Cabinet Policy of 2003 was not complied with, what then would have authorized the work that was done at the President's private residence? The Minister of Police gave us the National Key Point Declaration, where he declared the President's house is a national key point. Our reading of that declaration led to a conclusion that the National Key Points Act could be seen as one of the enabling frameworks for the upgrades that we're talking about. According to the declarations certificate issued by the Minister of Police, Mr. Natim Tetwa, on 8 April 2010, the security installations at the President's residence were supposed to be handled in terms of the National Key Points Act. But since work was already in progress, the directive in the declaration was to presumably apply from that date onwards. Unfortunately, the organs of state involved have not addressed me on what was intended when the Minister of Police declared this place as a national key point, and asked the President to pay for the upgrades. They haven't indicated what was going to be the relationship between the application of the National Key Points Act and the application of the Cabinet Policy of 2003. Nonetheless, I have arrived at the conclusion that from then onwards, the directive from the Minister of Police should have informed what happened at Nkandla. And that directive was asking the President to pay. Whether it was a right directive or a wrong directive, somebody had to act on it. If I'm right, therefore, in this conclusion, then it means then that the Minister of Police, having asked the President to pay, then the President had to pay. I have arrived at this conclusion on the basis of the contents of the declaration. This is what the Minister of Police said to the President, quote, "The total safeguarding of a national key point comprises not only the measures which you, as owner, are obliged to implement in terms of Section 3.1 of the National Key Points Act, but also the effective protection which must be implemented by the protection unit." Full stop. It is therefore of the utmost importance that either you or a person appointed by you liaise with the protecting unit of this national key point and the provincial national key point officer to activate a joint planning committee for this national key point in order to draw up a joint plan to counter an incident. The Minister of Police proceeds as follows. In terms of Section 24D of the Income Tax Act, you can submit a claim for tax deduction in respect of expenditure incurred on security measures implemented at your national key point. It is trusted that you will implement your security obligations as defined in Section 3.1 of the National Key Points Act of 1980 at your national key point. I must clarify there that there are two options. The Minister of Police can use Section 3.1 to say the owner of a national key point must secure the national key point himself or herself. Alternatively, the Minister of Police may, if he sees that the owner is unable or unwilling to secure the national key point, declare then, or rather provide for the security of the national key point himself. I will then explain later what then happens in that regard. In this particular case, though, it is important to understand that he said the following. This directive contains all information you will need in reference to the administration and safeguarding of your national key point. He even says, please study it carefully. He then concludes by saying, I quote, if the circumstances of your national key point should change to such a degree that its status as a national key point is affected, you must inform the national key point section so that a re-evaluation can be carried out. You may wonder, why is this important? It is important because the argument that has since been presented towards the conclusion of the investigation is that there was never an intention to ask the owner of this national key point to pay for the national key point. It was said that the place was declared as a national key point not for the security installations, but to be protected after the security installations. What has not been indicated is what is it then that the owner was being asked to install or to pay for. We also have not found any evidence that this decision of the Minister of Police was revoked. During the investigation, we have asked the parties involved what their understanding was regarding who was supposed to pay for the installations after the place was declared as a national key point. I've indicated that in their view, they understood that everything was to proceed according to the original arrangement under the Cabinet policy of 2003. I apologize about that, but we will proceed nonetheless. My apology, but
maybe we can pause while they fix it. The light, because I think for the TV people it's going to be a huge. Yes. Yes, I'm saying maybe we can just give it 5 minutes or 2 minutes. Then I'm not sure. If indeed. Yeah. We'll continue. Are we fine?
Yes.
All right.
Hallelujah.
It's fine.
All right. I've been advised that I may continue. We apologize for the interruption. Firstly, I was. Yes. Firstly, I was at a point where I was explaining that we had to then determine which enabling policy or legislation was applicable after the place was declared a national key point, and government has indicated that it certainly was not the National Key Points Act, it was the Cabinet policy. From our side, or rather from my side, I also had to consider the possibility that perhaps Section 32A of the National Key Point Act was then brought in. This section, as indicated earlier, gives the minister the power to pay if the owner is unable or unwilling. However, there's no document that shows that the minister revoked his decision from using Section 3.1 to using Section 3.2 or Section 3A. There's no document to that effect. The minister himself has said the following in response to the provisional findings. Codes, open codes. Any contention that the President was required to implement security measures at his private residence at his own expense for his own safety and security is misguided and incorrect. This very difficult to understand view was also presented by the Presidency in response to the provisional report. I have indicated that the legal advisors of the President said that this was not asking the President to pay for the installations that we're talking about. I then asked, what was he being asked to pay for then? I was not able to find an answer from any of the participating departments. What we do know, though, based on the evidence that has been given to us, is that throughout the project, there were discussions on items that we regarded as items for the owner's account. We even have evidence of a draft apportionment letter, which was prepared at the request of the then Deputy Minister of Public Works, Ms. Henrietta Bokopane-Zulu. Apart from that letter, there are minutes that show continuous discussions on items that kept being referred to as items for the owner's account. Unfortunately, although the Deputy Minister has confirmed requesting this apportionment document, and the fact that the evidence shows that it was duly prepared, she could not confirm that the document in question was sent to the President. Neither could Ms. Mahlangu Kabinde confirm, given the fact that she was the Minister of DPW at the time. There is clearly no evidence of a decision made by the Minister of Police as required by law to act in terms of the apportionment regime. The Presidency also argued very soundly that there is no obligation for the President to pay for security upgrades at his home. Even when you look at the Cabinet Policy of 2003, there's no provision that the owner should pay. And in the National Key Points Act, that's the only place where the possibility of the owner paying is considered. The Presidency argued very strongly that it would be unfair to ask any president to pay for his security if that is being done for him as a public office bearer. And that seemed to be in line with the spirit of the Cabinet Policy. Then we get to the expenditure at the request of the Department of Defense. This is the expenditure for the clinic and for helipads and then staffing quarters. I indicated earlier that we've not been able to find any concrete document that authorizes these. It has been argued that building bricks and mortar structures is part of the discretional power of the South African Medical Health Services, which is the military medical wing of the Department of Defense. The reading, though, of the instruments does not show that there's any provision for building a medical facility at the place of any one person. We then were struggling to find out how were these installations authorized. We're trying to find if they were authorized by the 2003 policy, the National Key Points Act, and the ones that are outside the fence that divides the state land and the president's land. We were trying to find out if those were authorized by legal policies of the Department of Defense. I've already indicated that minutes of the project team kept talking about apportionment, and several minutes talked to items as being for the owner. There's even a discussion at some stage of the swimming pool being on hold because it is for the owner's account, and Mr. Makanya at some stage was supposed to talk to the owner, and at some stage the Deputy Minister was supposed to speak to the owner. It is difficult to conclude that there was a decision to apportion costs at the level of the executive. We know that there was a decision to apportion costs at the level of the project team of officials, because it was the document for apportionment, of course, was agreed to at a project meeting and was duly prepared by the project manager, and according to him, duly submitted to the Ministry of Public Works. We have a copy of the document. The official copy, though, is still missing. Nobody seems to know what happened to it. Minister Bogopane Zulu says she went abroad, having requested the document, having complained about escalating costs. When she came back from the overseas trip, she was told, as she landed, while still wearing her traveling clothes, that she was now being removed from the prestige portfolio, which included Nkandla. Because of that, then she claims she never got the document, and she doesn't know what happened to the apportionment issue. Having indicated that we did get a copy of the document, of the apportionment document, it does disclose that there are items that were ticked by Mr. Kanyile as items for the owner's account. I must just indicate, though, that the disappearance of the document amid a situation where virtually all of the members of the executive involved appeared conversant with its contents is a source of grave concern. As I've indicated, that at the level of the project team, it was prepared and it was submitted to the appropriate authority. How is it possible that everyone knows about its contents, yet nobody knows what happened to it, and nobody admits to having seen it? It's difficult to understand. Of course, it does, though, leave us with the understanding that then there wasn't a decision, at least at a political level, to go for the apportionment of costs. What we also know is that there's no evidence of a document that revoked the Minister of Police's decision from asking the owner to pay to either saying that he shouldn't pay or there should be apportionment. We had a procedural question that we needed to answer, though, was, did the President know that he had to pay, and was he consulted as required by law? If we go according to the declaration, the President was informed that he had to pay for everything. Curiously, though, the President appears to have been informed of such National Key Point declaration a year after it was made. The declaration was made in April, on the 8th of April 2010, by the Minister of Police. It is signed as recipient by the DG in the presidency on 7 April 2011. That's exactly 1 year later. At what point then was the president told that he would have to pay for some of the items? And which items was he supposed to pay for? It's not clear. The only evidence uncovered suggests that the owner was informed, or attempts were made to inform him of his partial payment obligations. Is the document purporting to be the apportionment document that we now have, but we're not sure if he got it. The other problem with the document is that it was only prepared at the beginning of 2011, when the security installations had started in 2009. That is the extent of the issues around what was installed inside the homestead. Let me just explain for those who do not know how the security upgrades were done. We talk about the inner perimeter and the outer perimeter. Inside the Zuma homestead, it is things that belong to the family, and when the president is no longer president, whatever is installed inside the homestead belongs to him and his family. Outside the president's house, there are installations on government property. That land has been leased by government and not leased by the Zuma family. When the president is no longer president and these are needed by the nation for some other purposes, they will be used because they will be belonging to the state. But what was done outside the president's property is more confusing than what was done inside the property. When we interface with the government departments, including during the inspection in local, we were informed that everything that was done outside the president's property was on the account of the Department of Defense and the South African Police Services. However, it has since turned out that the understanding from the Department of Defense was that everything was on the account of the Department of Public Works. The other confusing thing about what was done outside is the issue of the authorizing policy instrument. I've indicated that earlier. No such authorizing instrument was given. Generic instruments were given that empower the South African Medical Health Services to deliver military health services. We also looked at what was done with predecessors. That was not very helpful because when we looked at the closest we could find was a field clinic that was given to the late President Nelson Mandela. That was done about 3 years before his passing. And the other difference is that since the field clinic is a mobile clinic, when it's no longer needed, it will revert back to the state. Outside the president's property, there's also quarters for the South African Police Services. Of course, the South African Police Services can acquire buildings anywhere, but why these were done at the doorstep of the president was not explained properly. At the Nkandla residence, there's also the problem of households of neighbors that were relocated at state expense. Earlier on, we spoke about a certain Mr. Makanya, who was the president's architect and acting now as the principal agent of the state. We were told that it was his advice that these neighbors be moved because this fence needed to be straight for proper security. Mr. Makanya confirmed this during the inspection in local. What must be borne in mind, though, is that 2 security evaluations were done by actual security experts, and none of those security evaluations complained about the possibility of a meandering fence and requested that the neighbors be moved. Also confusing is the fact that in the actual document that was prepared to authorize the removal of the families and the costs related to that, it was said that they were being moved because their proximity posed a security threat. They didn't make reference to the need for a straight fence. Of importance to me as a public protector was the issue of compliance with authority. As I indicated, we tried to find out what authority was used then to move them. If there was a need, what authority was used? Ordinarily, in the public sector, power belongs to the people. They yield some of those powers to those entrusted with public power through instruments. And those instruments would indicate what power you're being given and how to exercise that power. And if you have a discretion, those instruments would indicate you have discretion. We were not given a single instrument that indicated that the state had been given power to move those families. You will see that in the Act, we talk about the Expropriation Act, which was not invoked. That Act also has its own provisions around when can it be invoked, how can it be invoked, and what are the consequences. I have noted particularly with concern the submission by the Deputy Minister, who was the Deputy Minister of Public Works at the time, Ms. Bokopane Zulu. In her interview, she has stated that she had advised that the households be moved with the assistance of the Minister of Human Settlements. That would have then put them under the RDP program, given the fact that they are modest homesteads anyway. The evidence suggests that they were not in the right condition. This would have cost between 100,000 and 120,000 per house. The cost at the moment is that those households were moved at the cost of 8 million. The 8 million paid for 15 rondavels that were built for these families. The next part of the conversation, we deal with supply chain management processes and how these were supposed to have been followed. Key to this is that it is now common cause that an excess of 215 million rand has been spent at the project. That started at 27 million rand. Treasury rules require that anything that is procured has to be procured in accordance with set specific rules. All goods and services between 10,000 and 5,000 rand must be subjected to 3 quotations, and above 500,000 to an open tender process. Between 10,000 and 500,000, it's 3 quotations. Above 500,000, it's an open tender process. Secondly, if you're not going to go through these, there are provisions for deviations. And the specific rules for deviations, agency, that person is the only provider, or if that person is the only provider of that service. In Nkandla, we do know that there were deviations, and this is how they were justified. Security. 2, the fact that a particular service provider was appointed by the president and that there was a need to integrate the project with the president's private works. 3, there was instruction from the Minister of Public Works. 4, there was agency. 5, indications that the service or product required was only available from one supplier. And they also used nominated processes. As I indicated, agency is allowed and a single service provider is allowed. In this particular case, I have difficulty understanding why Mr. Makanya and the other consultants and contractors brought in on account of prior involvement with the President's private renovations were considered key to the work relating to the helipads, the clinics, the homes for the South African police members, and relocation of households. You'll recall that the argument was that because they were involved intimately with the structures that were being built inside the homestead, it was important to integrate the work. Regarding the work that was done outside, it is unclear, therefore, why that argument sufficed for deviating from Treasury requirements. In the allegations, it was said that, in the allegations during the investigation, it was said that Mr. Makanya and the others were brought in because somebody said the president preferred them. The president denied this, and no evidence was found that was showing that the president specifically said that they should be engaged. He has submitted that he never insisted that Mr. Makanya and others needed to be involved. He has explained that he simply participated in a meeting where Mr. Makanya was involved. I would like to quote his exact words. He says he participated in a meeting, I quote, where he participated at that meeting only to introduce my architect to senior government officials and to appraise each other of their respective plans. It is common cause that Mr. Makanya not only served as principal agent for the President's private work and the state-funded Nkandla project, it was also common cause that he served as overall architect, providing subcontractors to the Nkandla project while serving the President as his private architect. Also not denied is the fact that Mr. Makanya, throughout the Nkandla project, served as the go-between between the government officials and the President. You will see that in references to minutes. He was left to discuss designs with and explain the President's preferences to the project team. What is particularly disturbing in this regard is that the minutes show that Mr. Makanya was often asked to design something more economic, and he would come back with something more expensive or even luxurious, and then make a submission regarding why the security need in question needed to be met through the more costly design. An example in this regard is his decision to change the design and location of the safe haven at a significant increase to the cost. You'll notice in the report that we don't mention where is the safe haven, because one of the objections to the original draft of the provisional report was that it would compromise the security of the president if we mention where is the safe haven. The reality is that that is already in the public domain, but nonetheless we have complied. But the original design, we know that it was going to cost 500,000. And what we have built has now cost 19 million, and it's incomplete. Despite denials by the presidency, the appointment to design and implement security features at the president's residence placed the service providers, who were also appointed by the president, in a position of dual responsibility to the president and to the DPW. And also, although denied by the presidency, I'm unable to conclude that this did not present a risk of conflict of interest. This was particularly the case with Mr. Makanya, whose new role as principal agent for the entire Nkandla project meant that he became the state's main advisor on what it would take to cost-effectively meet identified security requirements while maintaining his status as the president's architect and advisor. In fact, the DPW never explained why Mr. Makanya had to be the principal agent for the entire project, other than to indicate that he was already involved in the president's private works. He could have been consulted on matters that involved him. He could have been one of the architects. It wasn't clear why he became the principal agent. Mr. Makanya's third role as the main go-between, or as the main link between the president as owner and the project team, also placed him in a position of serving the interests of two masters. The presidency has argued that there is no evidence that the interests of the two masters were conflicting. That may be so. What we do know, though, is that many of the modest measures originally recommended by the security evaluation or agreed to at project meetings ended up being replaced through the designs of Mr. Makanya and the team under him by more expensive measures. Placing Mr. Makanya between the project team and the president evidently shifted power from state officials to Mr. Makanya. In his written submission, one of the official project managers stated that Mr. Makanya became the de facto project manager, and it was difficult to exercise control over him, leading to a case of the tail wagging the dog. It is not difficult to comprehend why government officials, particularly at a fairly low level of the food chain, would have difficulty controlling a consultant who was presented by and claims to speak with the president's concurrence or authority. It is also possible that even a minister could have had difficulty countermanding Mr. Makanya. The minutes of the project team reveal knee-jerk reactions to situations where at each meeting new security issues were discussed. Somebody would be asked to go and design a feature that could capture the idea they had in mind, and then it would be taken to a quantity surveyor for costing, and then at the relevant meeting it would be simply adopted. During the inspection in loco, Mr. Makanya, who battled to explain items such as the amphitheater, the crawl, which includes a chicken run and a cattle culvert, the visitors center, the swimming pool, expensive paving, and the relocation at state expense of the president's neighbors was deferred to by the team. The last issue around the conflict of interest, or at least the risk of conflict of interest, is the fact that Mr. Makanye was paid on a percentage basis. Of course, then the more extensive the scope, the higher would be the percentage, the amount involved in the percentage. We now know that when they were hired, the amount that was authorized was about 400,000 per contractor. Today, Mr. Makanye has been paid 16.5 million from the Nkandla project. Coming back to the issue of procurement, I have already indicated that the Treasury rules have very specific requirements on agency. I draw attention specifically to Treasury Regulation 16A.4. Mr. Kanyile, the regional manager of the Devon office of DPW, considered in his evidence that from the time the project commenced, the procurement procedures followed were different from the norm usually applied by the South African Police Services, the DOD, and the Department of Public Works. He considered that these organs of state failed to comply with the prescribed standards of proper demand management and budgeting. The Minister of Public Works has, in his official statements, also considered this point. The task team of officials from DPW SABC and Security Ministry also confirmed the same in its findings. The evidence of the officials involved indicates that they erroneously accepted that due to the fact that the project related to the security of the president, which was urgently needed, and because it was driven from DPW head office and the Minister of Public Works, the deviation from the norms was justified and not to be questioned. And this evidence was corroborated by Mr. Malibe, who was the acting Director General of DPW at the time. Mr. Malibe took responsibility for the shortcuts. He further indicated that he had been involved at trench level and that not only him alone was involved, the Deputy Director General was involved, the Deputy Minister, and at some stage the Minister and officials from the Durban office were involved in the implementation. And that this then created confusion regarding roles and the accountabilities for procurement decisions. In the report, I have documented various transactions that were made against the rules. And one of them is the fact that Mr. Kanyile submitted an internal memorandum to Mr. Malibe, which asked Mr. Malibe to give him power to procure items up to 20 million without going through the DPW Special National Bid Adjudicating Committee, which then gave him and the Regional Bid Adjudicating Committee a lot of power and authority. This Mr. Kanyile was also given, in his own capacity as accounting officer, Mr. Malibe also approved the appointment of consultants and contractors for millions of rand by means of nominated or negotiated procurement strategies. I have already indicated that the justification of these on agency did not apply in respect of most of them, or rather the justification was not supported by the evidence. It must be noted that the scale of the project increased exponentially in terms of the number of items, the size of measures, and the size of the president's homestead. In the construction industry, a runaway project scale is referred to as scope creep. Scope creep is primarily attributed to lack of or poor demand management and failure to manage service providers who are known to find ways to expand their brief, leading to greater cost and extended periods of engagement. Some of the dimensions of the scope creep were a consequence of constant add-ons to the original list of security measures. We have primarily looked at the two security evaluations and items that were not included in those. For example, landscaping was not included in those, although later I'm going to discuss why landscaping came about. It is clear that there was a failure of demand management, and that is discussed very broadly in the actual report. On the issue of demand management, in the report, I draw attention to the role of Ms. G. Paisley, who was the Chief Quantity Surveyor of DPW. On the 3rd of December 2010, she raised concerns about the escalating scope and costs. In her written communication to the project manager, Mr. Rindal, she said the following, among others, I quote, "The scope of work and estimated costs have increased considerably over the past 4 months and continue to change, which has given rise to further cost increases, as can be seen from the budget reports already submitted by the consultant team, and which are currently in the process of being revised again, full stop. The estimated costs have almost doubled over this period, and it is essential that the parameters in respect of the scope of work and the budget are established and confirmed, full stop. Information pertaining to the exact apportionment of work and costs is critical in order that a detailed cost analysis can be done by the consultant quantity surveyors within the confines of the budget." In the records of DPW, we were not able to find any evidence that attention was paid to Ms. Paisley's advice that the project be contained. It would appear that the project team was focusing on creating an ideal situation, but all of this is blamed on the procurement failures. I now turn to the role of SABC and DPW. You will note in the report that SABC does not seem to have concerned itself with the cost of whatever it placed on the menu. Brigadier Adendorf, the head of the Security Advisory Service of the South African Police Service, and SABC's principal representative in the Nkandla project, confirmed during her evidence that, in her view, the South African Police Services did not have any cost implications. She understood her role as not involving the costing of the installations. She understood that to be the duty of DPW. She also confirmed that she had not operated according to the Cabinet Memorandum of 2003, nor the National Key Point, in the National Key Points Act. Then the Department of Defense, there the main actor was General Ramla Khan, who pointed to several defense prescripts that authorize his work. With the support of two councils, he contended strongly that he understood his role as having been confined to making a wish list, and for the DPW to adjudicate on that list, procure and provide whatever it chose to provide. And he also understood that payment was supposed to come from DPW. Despite General Ramla Khan presenting himself as the expert, even questioning my own competency to question what he requested, he maintained that it was not his place to ensure that the needs identified in relation to military health services in support of the President, his family, and military staff deployed in Nkandla were addressed through the most cost-effective measures. It is difficult not to reach the conclusion that a license to loot situation may have been created by government due to lack of demand management by the organs of state involved, as provided for in the Cabinet Memorandum of 2003, the National Key Points Act, the relevant healthcare and transport regulations, and Treasury guides on procurement. Treasury prescripts clearly require government not to go to the market with a blank check, licensing service providers to simply fill the blanks relating to scope of work and amount to be paid. In the words of the project manager, Mr. Rindel, it was like building a puzzle without a picture. He says that the project team wrote the rules as they went along. Then we go on to talk about the measures that were paid for estate expense and whether these transcended what was required for the President's security. In the report, I have already indicated that we firstly looked at the instruments that control this, being primarily the Cabinet Policy of 2003, the minimum physical security standards, and the South African Police Services security evaluation reports. It is also important to note that the evaluation reports would have been prepared in conformity with the minimum physical security standards document. The key questions we had to raise in this regard related to some of the measures, whether or not these could be regarded as security measures. These were the visitor center, the crawl, which had a chicken run and an automated cattle culvert, the amphitheater, the swimming pool, and the extensive paving, among others. The first thing that was said by government was that I'm not a security expert, and therefore I'm not qualified to question the decisions of security experts on what is security. I concede that point, that I'm not a security expert. And my understanding is that it wasn't my role to be a security expert. My role was really what you call public scrutiny. It's administrative scrutiny of people who have the power to make a decision, and my role is simply to find out whether or not they have exceeded the boundaries of their authority. And that was the context in which I dealt with this. And in doing so, I was just guided by 3 documents. The Cabinet Policy of 2003, the Minimum Physical Security Standards Instrument, and more importantly, the security evaluation reports, because they indicated exactly what needed to be provided. I was advised by the lawyers representing the President that if I were to question the decision of security experts, then I needed to get another expert to give me a different opinion. Then I evaluate those 2. But what was conceded by them was that the bottom line had to be the list prepared as part of the security evaluation. And I did no more than that. To try and shorten the general conclusions, I am no longer reading every paragraph because the report will be provided to all who are interested in it. I just want to make one example of what we looked at. If we take the swimming pool, for example, we would look at what the minimum security standards instrument said. It is not there. Then you go to the lists that were provided by the security experts following the 2 evaluations. Again, you're not going to find the swimming pool. But thirdly, you'll find in the minutes conversations where throughout the deliberations, the swimming pool was mentioned as one of those items that were held in abeyance because it was considered as a non-security item and it had costs for the owner. Having listened to the submissions and measured these against the measures in private homes of previous presidents, and in the absence of some of these measures in the security evaluation reports, I had serious difficulty understanding the basis for classifying them as security measures. Some of the measures that I had difficulty with are the following. If you look inside the private residence, we have the visitors center, the kettle crawl with a chicken run, the amphitheater, the marquee area, and the swimming pool. I've already indicated that many of these measures had been the subject of discussions around who was going to pay for them, and at some stage they were held in abeyance because there were supposed to be discussions on whether or not they were acceptable to the owner and whether they were going to be paid for. Let us go to the swimming pool. In the report, I refer to a project meeting where the following was said. Mr. Makanya was also requested to discuss the issue of the fire pool with the President. It was further recorded that, I quote, Mr. Makanya said that the pool has been placed on hold because of the pool bearing a private costing, which the principal, brackets, the President, did not accommodate for. Close quotes. Regarding the visitor center, There's currently an empty building belonging to the Zuma family that could have been used by SABC for the purpose which it is said the visitor center was built for. It was said that the visitor center was built to contain visitors that could end up walking all over the place, which potentially presented a security risk. There are two problems with it. The first one is that there is that other room, but the other issue that I raise in the report is the fact that when there were items, security items that were needed, and then there was no authority to implement those, was it up to the task team to give itself authority? Or should the task team have accepted that it was confronted with a novel situation and then needed authority, to request authority from someone to address those novel situations? There was a lot of media concern regarding the issue of a tuck shop. The evidence shows that the original tuck shop exists, and the information given shows that the new tuck shop is not really a tuck shop. It is a building that is housing other security features, and the tuck shop is one of those. It was difficult to reject the arguments regarding the tuck shop as a necessary security measure. Also, with the tuck shop, we must indicate that it is in the security evaluation reports. It is not one of those things that just cropped up. On state land, the items that are built there are a private clinic, helipads, and staff homes for the Department of Defense and the South African Police Services. The arguments that have been advanced by the organs of state for the necessity of these measures are difficult to reject. However, I found no reason why these measures were located near the private residence rather than a central place that could have benefited the entire impoverished Nkandla community. The government's submission makes a point of highlighting the inhospitable terrain of Nkandla, coupled with, at the time, lack of infrastructure such as roads, properly resourced health facilities, and police stations. General Ramla Khan has indicated that there are no such central places to place these facilities at a central point. But this is contradicted by evidence of the existence of police stations and clinics where the helipads could have been placed. The police staff quarters themselves could have been placed at a local police station. General Ramla Khan also said that this was not the first time South Africa used public funds to build facilities close to a president. He alluded to the George Airport as having been built within a stone's throw of the then President Botha's private residence in Wilderness. Firstly, that airport is 23 kilometers from the said private residence. Secondly, it supports the point about catering for the needs of the caretakers in a manner that takes into account that public resources should be primarily deployed to meet public needs. In other words, the George Airport is not placed next to anyone's house, even though it may have been conceived to support the president, which we didn't investigate. All we investigated was where is it in terms of proximity to the house. Also of concern was the amounts involved in implementing the measures, and the real concern being that the amount is obscenely excessive. I really could not find any authority or legitimate reason for classifying the relocation of the households of neighbors at state expense as a security measure. No authority was given to me by any of the people involved. It's not in the minimum physical security standards. It's not in any of the security evaluation reports. And as I indicated earlier also, there was no evidence that cheaper alternatives were explored. One of those being the National Key Points Act, which allows you to declare a national key point precinct that would then cater for a cluster of national key points. The Ministers of Public Works communication with Parliament, the nation, and possibly the President was riddled with inaccuracies and inconsistencies, particularly regarding the regulatory framework employed to justify state expenditure on the upgrades at the President's private residence. The nature of the upgrades and the extent to which the President and his family benefited from the relevant installations. This, I must say, has grossly undermined trust in government. I'm not making a finding here, it's just an observation that the communication around what exactly was being built by the state could have been handled better than the way it has been handled. On the allegation that expenditure for the state was excessive, we do know that the project started at 27 million. It is now at 215 million, whilst it is incomplete. The only point here that I'm going to make, to just avoid repeating what has already been said, is how does the expenditure at Nkandla compare with expenditure previously? The point I want to make is for two reasons. The one is the issue of excessiveness, but more importantly is giving us an idea of what was envisaged when the regime was conceived. Because the pricing should be comparable if the kinds of items that were used here were envisaged at the time these instruments that enable the installations were conceived. According to information submitted by the DPW and the Department of Defense, R20,001 was spent on former President Botha's private residence. It was 20,000. That equates to 173,333 in 2013. At former President de Klerk's private residence, the amount that was spent at the time was 42,196. In today's terms, that amounts to 236,484. At President Mandela's two households, the one in Kuno and the other in Johannesburg, the amount spent was 32 million. This includes the field clinic that I've referred to at the cost of about 17 million. The field clinic will revert to the state with the President having passed on. At President Mbeki's private residents, the amount spent was, at the time, 8,113,703 rand. That amounted in 2013 to 12,483 rand 938. Judging by these amounts, it is clear that the installations envisaged in the name of security are items you are likely to find at a security shop or company regulated by the security industry regulator, and not the kind of construction work done under the rubric of the Department of Human Settlements or the built industry. The fifth issue was possible maladministration by officials. I will not deal with it now. I have dealt with it extensively in the report, how the procurement requirements were not adhered to. But also key is the fact that it was the duty of the officials to advise the executive authorities on what was needed under all of these instruments, whether you are talking about the defense ones or you're talking about the ones regulating the work of the South African Police Services and Public Works. In the report, it would show that this duty was not met. We have already indicated that at SABC, the brigadier that that assisted SABC was not familiar with the cabinet policy of 2003, nor with the National Key Points Act. We have already informed you that the Minister of Police was asked to sign a declaration certificate that asked the President to pay, but no follow-up was done to make sure that the President paid. With the Department of Defense, you will note in the report that we refer to minutes where the Department of Defense was asked to submit norms that were supporting the wish list that had been submitted by the department, and those norms were not submitted. In my discussion with General Ramla Khan, he was not able to give me specific norms. He gave me generic instruments that don't deal with the provision of specific services at a private president, Minister of Defense, or international dignitaries' home. Those instruments just deal with the provision of military health services by the Department of Defense. We had sight of the instrument that he used to make the decision. In the instrument, there's a paragraph that says legal policy framework. It simply says something to the effect that the normal treasury regulations and military doctrines are sufficient to authorize this. That doesn't help anyone to make a proper decision. I would like to move to the findings. And I will try to summarize the findings. That was generally what happened, the storyline of what happened. The first finding relates to the authority, the legal authority to install any security installations in the construction of buildings at the President's private residence. Here I indicate that the only authority we could find was from the Cabinet Policy of 2006, the National Key Points Act, the Defense Instruments, which is primarily the Defense Review, and the instruments, the defense instruments dealing with the transportation of the President, Deputy President, and others. My finding is that there was authority for some of these things, and there was no authority for others. I'm therefore making a finding that whilst there was authority, the authority was exceeded, and where there were procedures to be followed, they were not complied with or not fully complied with. Specifically, I have found that the Cabinet Policy of 2003 was violated because of the deviation from 16 security measures that were recommended from the security evaluation to the many measures that were implemented outside that recommendation. This constitutes improper conduct and maladministration. I also find that the National Key Points Act was not complied with, particularly the declaration of the minister, which specifically asked the President to pay. In relation to installations at the request of the Surgeon General on behalf of the Department of Defense, there appears to be no instrument specifically authorizing the construction of brick and mortar installations at or for a private household. These have been justified on generic military doctrines aimed at installations built in pursuit of public services and the general power given to the SAMs to provide health services to the President, Deputy President, Minister and Deputy Minister of Defense, and at the request of the Minister of International Relations, foreign dignitaries. Finding number 2. Was the conduct of relevant authorities in respect of the procurement of goods and services relating to the Nkandla project improper and in violation of relevant prescripts. My finding is that the organs of state involved in the Nkandla project failed dismally to follow supply chain management prescripts, such as Section 217 of the Constitution, the Public Finance Management Act, Treasury Regulations, the DPW Supply Chain Management Policy. Key omissions in this regard include the following. There was no demand management. There were improper delegations. And there was failure to procure goods and services that are above 500,000 rand through a competitive tender process. There was also failure to conduct due diligence, leading to the engagement of service providers such as the principal agent without necessary qualifications or capacity for security measures. Finally, there was failure to ensure security clearance for some of the service providers and allowing scope creep, which has led to exponential scope and cost escalations. I've also found that the Department of Public Works failed to comply with the provisions of GIAMA, which specifically requires a proper asset management plan in respect of the immovable assets of the state. 3. A sub-finding under finding number 2 is that the conduct of organs of state involved in managing the Nkandla project particularly the officials from DPW who failed to comply with supply chain management prescripts, was unlawful and constitutes improper conduct and maladministration. The DOD and SABC officials failed to comply with Treasury Regulation 16A/2, which impose a responsibility for demand management. Demand management includes ensuring cost-effective measures and budgeting appropriately for such. Finding number 3. Did the measures taken by the Department of Public Works at the President's private residence go beyond what was required for his security? My finding is that a number of the measures, including buildings and other items constructed and installed by the DPW at the President's private residence, went beyond what was reasonably required for his security. Some of these measures can be legitimately classified as unlawful, and acts involved constitute improper conduct and maladministration. One of those unlawful measures is the relocation of the neighbors. Measures that should never have been implemented, as they are neither provided for in the regulatory instruments, particularly the Cabinet Policy of 2003, the Minimum Physical Security Standards, and the Sub-Security Evaluation Reports, nor reasonable, as the most cost-effective measures to meet incidental security needs include the following. The construction of the Visitors Center, an expensive cattle crawl with a culvert and chicken run, a swimming pool, an amphitheater, the marquee area, and some of the extensive paving. The relocation of neighbors who used to form the original homestead at enormous cost to the state also constitutes one of the measures that should never have been implemented. I have already indicated that the relocation was unlawful as it did not comply with Section 237 of the Constitution. The implementation of these installations involved unlawful action and constitutes improper conduct and maladministration. Then there are measures that are not expressly provided for, but could have been implemented in a manner that benefits the broader community. These are the measures from the defense where I have accepted that the Department of Defense has said that there were certain minimum conditions that were required for the Department of Defense to be able to support the President from the point of view of military, health services, and transport. That has been accepted. My finding, though, is that the measures that were used could have been located within the broader community. And these include the helipads, the clinic, and the South African Police Services staff quarters. The failure to explore more economic and community-inclusive options to accommodate the discretionary security needs constitutes improper conduct and maladministration. Finding number 4 was the expenditure incurred by the state in this regard excessive or amount to opulence at a grand scale as alleged. My finding is that the expenditure incurred by the state in respect of the measures taken, including buildings and other items constructed or installed by the DPW at the request of SABC and the DOD, many of which went beyond what was reasonably required for the President's security, was unconscionable, excessive, and caused a misappropriation of funds. The failure to spend state funds prudently is a contravention of Section 195(1)(b) of the Constitution and the Public Finance Management Act. The acts and omissions involved are accordingly unlawful and constitute improper conduct and maladministration. My finding, therefore, is that the first complainant's allegation that the expenditure constitutes opulence at a grand scale is substantiated. The acts and omissions that allowed the excessive expenditure due to non-security items and failure to arrest the wild cost escalation, especially after the story broke in the media in December 2009, constitute improper conduct and maladministration. Finding number 5, Did the President's family or relatives improperly benefit from the installations implemented by the state at his private residence? The allegation that President Zuma's brother improperly benefited from the measures implemented is not substantiated. I could find no evidence supporting the allegation that the President's brothers benefited from the procurement of electrical items from the implementation of the Nkandla project. The allegation, though, that the excessive expenditure added substantial value to the President's private property at the expense of the state is substantiated. The excessive and improper manner in which the Nkandla project was implemented resulted in substantial value being unduly added to the President's private property. The acts and omissions that allowed this to happen constitute unlawful and improper conduct or maladministration. The allegation that President Zuma's immediate family members also improperly benefited from the measures implemented is substantiated. President Zuma improperly benefited from the measures implemented in the name of security, which include non-security comforts such as the visitor center, the swimming pool, amphitheater, cattle kraal with culvert, and the chicken run. The private medical clinic at the family's doorstep will also benefit the family forever. The acts and omissions that allowed this to happen constitute unlawful, improper conduct, and maladministration. I do not find the relocation of the tuck shop as a benefit, as the business was moved at the instance of the state to a building that might even be more inconvenient to the owner. Lastly, on the issue of benefits, my finding is that the conduct of the DPW leading to the failure to resolve the issue of items earmarked for the owner's cost transparently, including the failure to report back on the swimming pool question after the 11th May meeting, and the disappearance of the letter proposing an apportionment of costs constitutes improper conduct and maladministration. My sixth finding: was there any maladministration by public office bearers, officials, and other actors involved in the project? Public office bearers. All the ministers of public works provided incorrect information on the legal authority for and the extent of the works at the President's private residence. On this, my second finding is that the Minister of Police failed to properly apply his mind when signing the declaration of President Zuma's private residence as a national key point, directing the President to implement security measures at own cost or to properly modify the declaration. This failure constitutes improper conduct and maladministration. The former Minister of Public Works, Mr. Deutsch, and the Minister of Police could have provided better executive leadership, especially with regard to speedily assessing the extent and cost of the Nkandla project, particularly when the media broke the story in 2009, and taking decisive measures to curb excessive expenditure. The failure in this regard constitutes improper conduct and maladministration. I then go to officials of the Department of Public Works. The first finding in relation to officials is that the Department of Public Works officials failed to acquaint themselves with the authorizing instruments relating to the implementation of the Nkandla project. They failed to apply their minds and adhere to the supply chain management policy framework in respect of the procurement of the goods and services for the Nkandla project. These failures constitute improper conduct and maladministration. I also find that Mr. Malive and Mr. Vukela, the acting directors general of the Department of Public Works, failed as accounting officers of the department at the material times to comply with and or to ensure compliance with the provisions of Section 195 1B and 217 of the Constitution, the Public Finance Management Act, Treasury regulations and prescripts, and the DPW supply chain management policy in respect of the Nkandla project. And this constitutes improper conduct and maladministration. In respect of officials, I also make the following important finding. Ms. G. Paisley, the chief quantity surveyor, showed exemplary conduct by raising her concerns about the excessive escalation in the cost of the project. It is unfortunate that her concerns in this regard were not taken seriously. In other words, we're not only making findings of improper conduct and maladministration. In this particular case, I'm making a finding of proper conduct and good administration. The officials of the SABS. The SABS officials failed to acquaint themselves with the authorizing instruments relating to the implementation of the Nkandla project. They failed to apply their minds and to adhere to the supply chain management policy framework in respect of the procurement of goods and services for the Nkandla project. These failures constitute improper conduct and maladministration. Finally, I make the finding in respect of the SABS officials that Brigadier Adendorf, the head of Security Advisory Service, failed to comply with and or to ensure compliance with the provisions of Section 195 1B and 217 of the Constitution, the PFMA, Treasury regulations, and prescripts in respect of the area of her responsibility relating to the Nkandla project. Her conduct in this regard was improper and constitutes maladministration. Officials of the Department of Defense. My first finding in relation to these officials is that the DoD officials failed to acquaint themselves with the authorizing instruments relating to the implementation of the Nkandla project. They failed to apply their minds and to adhere to supply chain management policy framework in respect of the procurement of goods and services for the Nkandla project. These failures constitute improper conduct and maladministration. The second finding is that General Ramla Khan, the Surgeon General, failed to comply with and/or ensure compliance with the provisions of Section 195(1)(b) and 217 of the Constitution, the Public Finance Management Act, Treasury regulations, and prescripts in respect of his area of responsibility relating to the Nkandla project. His conduct in this regard was improper and constitutes maladministration. I must indicate that in the report I do indicate that I accept General Ramla Khan's contention that he didn't procure goods and services. However, I am saying that when he was creating that menu, that wish list, he had a duty in terms of the Constitution to order a list that firstly complies with the law, secondly is the most economic and efficient way of meeting the need he had identified. My last finding relates to the contractors, which is something that many people in the public would ask me, why would you make a finding against contractors? They're not employees of the state. In this regard, I request people to read the Mail and Guardian, the case of the Mail and Guardian versus the Public Protector South Africa. In that particular case, we did not follow the money because it had fallen on private hands. The Supreme Court of Appeal said to me, you should have followed the money. Jurisprudence internationally, when it talks about state action, it includes those who have been delegated authority to act on behalf of the state. If Mr. Makanya was not delegated authority to act on behalf of the state, then I would not understand what delegating authority to act on behalf of the state is. He was the principal agent who was entrusted by the state to look after its interests. I therefore find that Mr. Makanya's assumption of multiple and conflicting roles as principal agent, the president's architect, and procurer of some of the subcontractors, which placed him in a position where the advice he gave was tainted by conflict of interest and not in the public interest, leading to uncontrolled scope creep, cost escalation, and poor performance by some of the contractors, constitutes improper conduct. Of course, I'm not saying anything should happen to Mr. Makanya. I am just saying that placing him there was a form of maladministration on the part of the state. I then had to make a finding on political interference. Was there any political interference in the implementation of this project? The former Minister of Public Works, Mr. Deutsch, and Deputy Minister Bokopane Zulu were at some stage involved in the implementation of the Nkandla project. Their involvement although for a short period of time, appears to have created an atmosphere that was perceived as political interference or pressure. However, the evidence does not show that they indeed consciously created a climate of political interference. The task team report also indicated that officials were uneasy with the operational involvement of politicians in the Nkandla project. It's a question of perception, as opposed to saying that these ministers politically interfered. They have made a good case on why they went to the trench to try and fix the problem. Their involvement at trench level, including the Deputy Minister making suggestions on how to meet perceived security needs, was ill-advised, although well-intended, in the light of failures in meeting the project timelines. While I would discourage such acts in similar future circumstances, I'm unable to find their attempts at problem-solving as constituting improper conduct or maladministration. My eighth finding is where funds transferred from much other needed DPW projects to fund this project. The answer is yes. Funds were reallocated from the inner city generation and the dolomite risk management programs of the DPW. Due to a lack of proper demand management and planning service delivery programs of the DPW were negatively affected. This was in violation of Section 237 of the Constitution and the Batupile White Paper, and accordingly constitutes improper conduct and maladministration. You will recall that Section 237 says that constitutional dictates must be met expeditiously and diligently. In other words, then you can't take money that is meant for meeting basic needs such as socio-economic rights and fund a project that is not even legally justified. My ninth finding is the President liable for some of the costs incurred? My finding is that if a strict legal approach were to be adopted and the National Key Points Act was complied with, President Zuma would be held to the provisions of the declaration of the Minister of Police issued on 8 April 2010. This declaration informs him of the decision to declare his private Nkandla residence as a national key point and directs him to secure the national key point at his own cost. My second finding in relation to the cost issue is, however, that approach would not meet the dictates of fairness, as presidents, deputy presidents, former presidents, and former deputy presidents are entitled under the Cabinet Policy of 2003 to reasonable security upgrades at their request or the request of their office at state expense. Even on the understanding that some of the measures were unauthorized and transcended security measures as envisaged in the regulatory instruments and security evaluation findings, the questionable measures implemented exceed the financial means of an ordinary person. We're talking about 215 million of the whole project. If you isolate from that project everything that was in the security evaluation reports, you'll find that the bulk of the money was spent on things that were not on the list, or the list had recommended something smaller or modest. It is further clear from all communication by President Zuma that he was never familiarized with the provisions of the National Key Points Act. And specifically, the import of the declaration. The declaration itself was apparently delivered to his office in April 2011, a year after it was made and more than 2 years after the security installations had commenced. The DPW mismanaged the process, initiated with a view to determining the cost to be paid by President Zuma in respect of security measures installed at and in support of his private residence at Nkandla, and which was initially estimated at more than 10 million. This led to a situation where to date there is no clarity on that matter. This constitutes improper conduct and maladministration by the DPW. It is my considered view that the President, though tacitly accepted the implementation of all measures at his residence and has unduly benefited from the enormous capital investment from the non-security installations at his private residence. A reasonable part of the expenditure towards the installations that was not identified as security measures in the list compiled by the security experts should be borne by him and his family. It is also my considered view that the amount in question should be based on the cost of the installation of some or all of the items that can't be conscionably accepted as security measures. These include the Visitors Center, kettle crawl, and kitchen. These include the Visitors Center, the kettle crawl and chicken run, the swimming pool, and the amphitheater. The President and his legal advisors did not dispute that in their response. The President did not dispute during the investigation that he was involved in the building of the crawl and that he was willing to reimburse the state for the cost thereof. His legal advisors also did not dispute this in their response to the provisional report. At least we can have some agreement on the kettle crawl. We could also have some agreement on the swimming pool if we look at the minutes of the project team, which show that it was never meant for the state's expense, or at least a portion of the swimming pool was never meant for the state's account. Finding number 9, were there ethical violations on the part of the President in respect of the project? President Zuma told Parliament that his family had built its own houses and that the state had not built any for him or benefited them. This was untrue. It is common cause that in the name of security, government built for the President and his family in his private residence a visitors center, a kettle crawl, a chicken run, a swimming pool, and an amphitheater, among others. The President and his family clearly benefited from this. I have accepted the evidence that he addressed Parliament in good faith and was not thinking about the visitors center and the other installations, but his family dwellings when he made the statement. While his conduct could be legitimately construed as misleading Parliament, it appears to have been a bona fide mistake. And I am accordingly unable to find that his conduct was in violation of paragraph 2 of the Executive Ethics Code. His statement is also consistent with those made by the Ministers of Public Works throughout the public outcry over the Nkandla expenditure. Regarding President Zuma's conduct in respect of the use of state funds in the Nkandla project, the only evidence currently available shows that the President failed to apply his mind to the contents of the declaration of his private residence as a national key point. In this regard, he specifically failed to implement security measures at his own cost, as directed by the Minister of Police. Alternatively, he failed to approach the Minister of Police for a variation of his declaration. It is my considered view that the President, as the head of South Africa Incorporated, if you like to see the country as such, was wearing two hats: that of the ultimate guardian of the resources of the people of South Africa, and that of a beneficiary of public privileges, of some of the guardians of public power and state resources. I believe the President should have ideally asked questions regarding the scale, cost and affordability of the Nkandla project. He also may have asked whose idea were some of these measures and viewed them with circumspection, given Mr. Makhanya's non-security background and the potential of misguided belief that his main role was to please the President as his client and benefactor. It is also not unreasonable to expect that when news broke in December 2009 of alleged exorbitant amounts, at the time 65 million, on questioned security installations at his private residence, the dictates of Section 96 and 237 of the Constitution and the Executive Ethics Code required of President Zuma to take reasonable steps to order an immediate inquiry into the situation and immediate correction of any irregularities or excesses. His failure to act in protection of state resources constitutes a violation of paragraph 2 of the Executive Ethics Code and accordingly amounts to conduct that is inconsistent with his office as a member of Cabinet, as contemplated by Section 96 of the Constitution. Regarding the allegation that the President may have misled Parliament and accordingly violated the Executive Ethics Code when he announced that the renovations at his private residence were financed through a bank mortgage, I'm unable to make a finding. Although having established through the Register of Financial Interests that the President has declared a mortgage bond in respect of his private residence at Nkandla since 2009, I am unable to establish if costs relating to his private renovations were separated from those of the state in the light of using the same contractors as those that were used by the state. Other findings of maladministration. The occupation by the state of land adjacent to that occupied by the President and where security and other measures were constructed and installed by the DPW is unlawful and improper, as it violates the provisions and requirements of the KwaZulu-Natal Ingonyama Trust Act that requires a proper lease agreement. This also constitutes maladministration. I must indicate this was not an allegation. However, we investigate alleged or suspected improper conduct. This is something that came up during the investigation. I also note that the conduct of some of the role players unduly delayed the investigation. During the investigation, there were systemic deficiencies that were observed. I make a finding as my 11th finding on deficiencies observed during the investigation. The first one is that the anomalies in the Nkandla project show the existence of systemic policy gaps and administrative deficiencies in the regulatory framework used as authority for implementing security measures at the private residences of presidents, deputy presidents, former presidents, and former deputy presidents. Key among these deficiencies is the absence of a cap and the absence of integrated instruments such as the ministerial handbook, where all permissible measures can be found. The second observation is that in view of the fact that the Cabinet policy of 2003 applies equally to presidents, deputy presidents, former presidents, and former deputy presidents, there is a real risk of a repeat of the Nkandla excesses in respect of any of the four covered categories of public office bearers in the future. As the policy applies to all residences of incumbents in any of the four categories, the risk of unbridled expenditure in the future is very real and needs immediate curbing. I have found that regarding the DOD deficiencies, including having no instruments for extending and regulating the exercise of discretion, and having a concentration of power on a single individual with no accountability arrangements, has emphasized the need for a proper policy regime regulating security measures at the private residences of the President, Deputy President, Minister, and Deputy Minister of Defense. Lastly, I also find that there is a need for a clear demarcation of roles regarding what SABC has to do, DPW, and the DOD in respect of such projects. Also needing to be defined is who pays for what. My final observation relates to the impact of the Nkandla project, which is my 12th finding. A number of the items installed by the DPW, such as the safe haven, swimming pool, paved roads, and walkways, as well as water and electricity supply, will require lifetime maintenance at cost to the state. Some maintenance costs may transcend the President's lifetime. Secondly, the military clinic also requires maintenance, supplies, and permanent human resources as long as it exists, which may be beyond the President's lifetime. thirdly, the future of the buildings constructed at the request of the South African Police Services also needs to be determined. This is the police living quarters, which if they were at the police station, there wouldn't be an issue about them. I proceed to indicate the appropriate remedial action to be taken on my findings as envisaged under Section 182(1) of the Constitution. The President. I'm requesting the President to take steps with the assistance of the National Treasury and the South African Police Services to determine the reasonable cost of the measures implemented by DPW at his private residence that do not relate to security, and which include the visitors center, the amphitheater, the cattle kraal and chicken run, and the swimming pool. I'm also requesting the President to pay a reasonable percentage of the cost of the measures as determined with the assistance of National Treasury, and also taking into account the DPW apportionment document, which already placed these measures at a particular amount. I'm also requesting the President to reprimand the ministers involved for the appalling manner in which the Nkandla project was handled and state funds abused. My last request to the President is that he reports to the National Assembly on his comments and actions on this report within 14 days, which is a requirement under the Executive Members' Ethics Act. In this regard, let me just pause to indicate that the President's office has argued that his duty to account under the Executive Members' Ethics Act has lapsed because I did not meet the 30-day period for concluding the investigation, nor informed him within 30 days that I was not going to be able to conclude the investigation within 30 days. In the report, I have indicated that, firstly, that is incorrect. The investigation was conducted under the Public Protector Act from when it commenced at the beginning of 2012, having been launched under the Public Protector Act in December 2011. The request to investigate under the Executive Members' Ethics Act was only made in December 2012, a year after the investigation had commenced. I didn't immediately investigate because I firstly wrote back to the complainant asking whether she wanted me to investigate under the Executive Members' Ethics Act. And as soon as I got confirmation that I had to investigate under the Act, I proceeded to investigate, and 48 days after receiving the request to investigate, I advised the President that I now have an additional request to investigate the Nkandla project under the Executive Members' Ethics Act. For that reason, I do not think that the suggestion that the duty has lapsed is supported by the facts. But secondly, even if I had failed to meet the requirements, it can't be proper that if the public protector fails to comply with her duties, members of the executive then find themselves relieved of the duty to account to the public. The Executive Members' Ethics Act is an accountability instrument to Parliament. Members of the public can't complain under the Act. They may request their representative in Parliament, and the idea was to strengthen executive accountability. In the report, I also indicate why Emmy investigations are not concluded on time. Part of the problem is that I don't get the cooperation that I need. For example, with the presidents, we've calculated that it took 90 days to get a response. No, not 90 days, 9 months actually. We put a table in the report that shows it took 9 months. With the other ministries as well, there were delays. Because of the delays that we receive, we are often unable to conclude these investigations on time. The request I need from government is money and support to ensure that members of the executive who are asked questions respond on time. To the Secretary to the Cabinet, I request him or her to take urgent steps to, 1, update the Cabinet policy of 2003 to provide for a more detailed regime. 2, assist Cabinet to set clear standards on the security measures that can be taken, the reasonable cost that can be incurred by the state, and the conditions subject to which current and former presidents, deputy presidents, and others would qualify for such measures. 3, take periodic measures to familiarize all members of the Cabinet with the parameters for enjoying executive benefits and the responsibilities they have to ensure that officials do not give them benefits transcending what they are entitled to under the law or policies. Lastly, I'm asking the Department of Defense to create standard operating procedures regulating the implementation of the benefits extended to presidents, deputy presidents, the Minister of Defense, the Deputy Minister of Defense, and other dignitaries. Such measures should be aligned with the principles of equality, proportionality, reasonableness, and justifiability, and this should be done within 6 months from the issuing of this report. I'm asking the Minister of Police to take urgent steps to expedite the review of the National Key Points Act, to clarify its applicability to presidential security privileges and align it with the Constitution and post-apartheid developments. I'm also asking the Minister to ensure that no further security measures are installed at the President's private residence at Nkandla, except those determined to be absolutely necessary for the functionality of already installed measures. And lastly, I'm asking the Minister of Police to ensure that the Nkandla project does not set a precedent for measures implemented in respect of any future president, former president, deputy president, and former deputy president. The National Commission of Police is being requested to identify officials that were and may still be involved in the Nkandla project and implement measures to identify why prescripts were not followed or complied with, and on the basis thereof, decide if disciplinary action should be taken, and to assist the Minister of Police in familiarizing himself with the contents of and his responsibilities under the National Key Points Act and the Cabinet Policy of 2003, and to ensure that in future, officials assisting ministers to take action under any law include in each relevant submission a copy of the legal instrument in question and an outline of all steps required of the minister. The Director General of the Department of Public Works is requested to take urgent steps to identify officials that were and may still be involved in the Nkandla project and implement measures to identify why prescripts were not complied with, and on the basis thereof decide if disciplinary action should be taken. With the assistance of the National Treasury, obtain advice from an independent and reputable security consultant on the security measures that were necessary for the protection of the President and estimated legitimate costs thereof. On the basis of this information, the DPW is to determine the extent of the over-expenditure on the Nkandla project and to obtain legal advice on the recovery thereof. With the assistance of the National Treasury, to determine the extent to which the South African Police Services and the DOD should be held liable for the expenditure incurred in the implementation of the Nkandla project and to recover the amounts accordingly. For to take urgent steps to ensure that a lease agreement is entered into with the KwaZulu-Natal Ingonyama Trust Board in respect of the property occupied by the state adjacent to the President's private residence. Take urgent steps to relocate the park homes to another organ of state that requires temporary accommodation. Review the delegation of authority to regional offices of the department. 7. Ensure that the DPW staff involved in supply chain management is properly trained on deviations from the normal prescribed procurement policies. 8. Ensure that all DPW staff involved in the implementation and execution of projects are properly trained and capacitated to manage projects assigned to them. Ensure that the South African Police Services comply with the provisions of GIAMA in respect of the assets acquired as a result of Nkandla project, and ensure that the Department of Public Works complies with GIAMA in respect of the assets acquired as a result of the Nkandla project. And finally, the Department of Public Works DG must develop a policy for the implementation of security measures at the private residences of the President, Deputy President, and former presidents and deputy presidents. To the Secretary for Defense, the request is to take urgent steps to consolidate prescripts relating to the medical transport and evacuation of presidents, deputy presidents, former presidents, and former deputy presidents. 2. Determine the role played by DOD officials, and in particular the SAMs, in the Nkandla project to ascertain if such role was in line with their remit and if legal authority boundaries and procedures were complied with. And lastly, to ensure certainty and accountability in respect of the future implementation of measures relating to the items referred to above. In order to monitor and ensure the implementation of the remedial action I have indicated above, the following steps must be taken. Firstly, when the President submits his report and his intentions regarding the findings and remedial action within 14 days of receipt of the report, the Director General and the Presidency should notify my office and the Cabinet. Accounting officers of all organs of state who are required to take remedial action are to provide implementation plans to the Public Protector Office not later than the 1st of May 2014. Status reports on the implementation are to be submitted by the affected accounting officers within 3 months, and final reports on action taken to be submitted within 6 months of the issue of this report. The public office bearers who are in affected organs of state are requested to ensure compliance. The question that arises is what is required after this report. I direct the President, Parliament, and other public authorities to the answer that I have found in the Constitutional Court decision in a matter called Kumalo and Another versus the MEC of Education in KwaZulu-Natal. The Constitutional Court in this matter highlighted the following, I quote, Section 195 of the Constitution provides for a number of important values to guide decision makers in the context of public sector employment. In their case, the matter was about public sector employment. When, as in this case, a responsible functionary is enlightened of a potential irregularity, Section 195 lays a compelling basis for the founding of a duty on the functionary to investigate and, if need be, to correct any unlawfulness through the appropriate avenues. This duty is founded, among others, in the emphasis on accountability and transparency in Section 195 1F and G of the Constitution, and the requirement of a high standard of professional ethics in Section 195 1A. These provisions found not only standing in a public functionary who seeks to review through a court process a decision of its own department, but indeed they found an obligation to act to correct the unlawfulness within the boundaries of the law and the interests of justice. 3. The public functionaries in the arms of the state are further vested with a responsibility in terms of Section 7.2 of the Constitution to, quotes, respect, protect, and promote and fulfill the rights in the Bill of Rights, close quotes. As bearers of this duty and in performing their functions in the public interest, public functionaries must, where faced with an irregularity in the public administration in the context of employment or otherwise, seek to redress it. It is my considered view that although the Khumalo case was dealing with employment, the thinking of the Constitutional Court is that if a public authority's attention is drawn to an irregularity, it is their duty to correct it. And incidentally, if the state had heeded its duty from 2009 when the media broke the story on the Nkandla project, it would have saved the citizens who invested trust and taxes in the public administration millions of rand. As a public protector or ombudsman, I do not make the rules. I simply enforce them. These rules would have been collectively agreed controls and values that are meant to regulate the exercise of entrusted power and resources within the state. The Constitution says that I have the power to determine right and wrong and to take appropriate remedial action. I have done so. Only if I was irrational can my findings be ignored. But even so, that process should involve a review by a court of law. Thank you.
How do you think he actually works?
Get fully installed fixed-line broadband with modem and turn your home into a Wi-Fi hotspot. That's 5 gigs data plus 5 gigs promo data for just $3.99, including ADSL and line rental. Plus, you'll also get a free 3G dongle with 200 megabytes mobile data a month and loads more benefits for your new connected home. Rethink fixed broadband. Call, click, go to a Telkom store. Get your business online with a T-Biz starter package from Telkom Business. Get up to 2 megabits per second ADSL